to all of you, and thank you so much for joining me on a cold and chilly Monday afternoon for what I think is a critically important topic. And the reason I think it's critically important is that, as the business community knows, we have literally been dropped in it by the Department of Education and Labor in two respects. The first is that there is no uh, safety net as of April, May, and June, as far as UIF TERS is concerned, for those companies which are essentially small businesses, but which do not give the Department of Education and the Department of Employment and Labor the big numbers. And so as a result, there are over 1 million employees in South Africa at the very least. And those are the official numbers, amongst 170,000 odd businesses. So we know they're all small businesses that remain unpaid for April, May, and June for UIF TERS. But nevertheless, and I imagine it's a lot bigger than that, by the way. We do know that June opened and then closed and has basically broken the UIF system and therefore is not operational any longer. All of that being said, this is the question I'm posing, and this is why I wanted to have this discussion with you. And this is not as much a webinar as it is going to be a discussion with you. I really want your views on what's going on and on what we're doing here. Because the reality is this: come the 1st of July, there is no TERS. So this, as things stand at this moment in time, come the 1st of July, there is no safety net of temporary employee relief which is available to you, the employer. The TERS system was implemented for April, for May, and for June, and that's precisely how it is going to remain. It was implemented for April, May, and June, and that's precisely how it's going to remain unless the President instructs the Minister of Employment and Labor to create an additional kitty for UIF TERS. It's relatively unlikely, only because they've not managed to manage the TERS system for April, May, and June. And as you know, they've been pushing it increasingly onto the employer as an excuse. So blaming the employer for TERS collapsing, number one. And then more importantly, you as the employer now have the obligation in terms of the employment relationship squarely back in your side of the field, on your side of the field. So come the 1st of July, there is no temporary employee relief, which means that your employees do not remain on temporary layoff. Now, this is critically important. This is a legal concept you have to get in your mind. They do not remain temporarily laid off from the 1st of July unless you have specifically come to an agreement with your employees in that regard. So temporary layoff ends on Tuesday this week. That's the first thing you have to know. So there's no TERS, and the temporary layoff ends on Tuesday this week. So come Wednesday, the 1st of July, your employees will no longer be considered to be temporarily laid off. And I'm just adding here, unless you have met with them, you have engaged with them, you have explained to them that there is no work available and therefore that they need to remain at home, and you have come to an arrangement with how you are going to honor their contract of employment with you. Now, I do need to say this, ladies and gentlemen. Come Wednesday, the focus is on how you as the employer are honoring your contract of employment with your employees. You are no longer in a position of having frozen that contract of employment and therefore temporarily laid off your employees, unless you have come to an agreement on the terms and conditions for continuing the temporary layoff. At best, we imagine that what you would be able to do if there is no work in your business which is available — when I say no work, I'm saying limited work — is at best you would have an agreement for a short time, or you would have an agreement for an extension of temporary absence. In other words, a layoff. Now, you can only have done that through an engagement. There has to have been an engagement that took place between you and the employees, which would have resulted in an agreement that they would go on short time. And short time, by the way, can include a rotation, a shift rotation, so that instead of them working, a full month, they could be working 2 weeks on a rotational basis or half a day on a rotational basis, so that there's short time. Or alternatively, if there is simply no space for them in your business, that they have agreed to a temporary layoff extension, and in return, you have agreed to pay them, to remunerate them, to compensate them in a particular way. What I've just said, I've said very quickly. So I want to give it a second for it, number one, to sink in, and for you to be able to ask any questions you need to ask in this regard before I carry on with what is a critically important thing, ladies and gentlemen, that you please do have to understand. Heinrich, you and I are in the same situation. What if we are still closed at the airports? Heinrich, if you are still closed at the airports, nevertheless, come the 1st of July, you are back into your employment relationship with those individuals, which means that it is incumbent on you to come to an arrangement with those individuals. And remember that you currently have a job description and a letter of employment with them that says that you employ them and you agree to remunerate them in a particular way. If you are still closed off and therefore are not trading at the airports, it's therefore incumbent on you to essentially get them to agree that it's a no work, no pay situation until such time that you open, but that they will not be entitled to TERS, and that you will have to offer as an alternative to them agreeing to no work, no pay until the business opens again because you've reached level 1, or alternatively because you are allowed to trade again until that time arrives, that as an alternative to being retrenched, they accept that they're temporarily laid off. There is no other way of doing it. You have to come to an arrangement and an agreement with them in this regard. There is no middle road. There is no assumption that they can remain temporarily laid off. And this is critically important. In fact, it is so important. I'm going to try and do this. I'm going to try and just take that off for a second. And I'm going to try and put myself on screen just for a second, Heinrich, to show you how earnestly I am actually making this point, and hope that you can understand the point that I'm making. The entire responsibility transfers to you as the employer from the 1st of July. You have no choice in the matter. You are completely responsible for them. And by the way, I want to add, you're equally responsible, Heinrich, for the fact that if those employees get sick, you're responsible for paying them sick pay. And that means if they contract the coronavirus, you're responsible for paying them sick pay. You're responsible as of the 1st of July from initiating your 36-day sick leave period. And therefore, a minimum of 2 weeks should they contract coronavirus. And more importantly, going on, therefore, for the full 36-day period. It's a responsibility that the government have passed directly onto you from the 1st of July. You have no choice in the matter. Heinrich, maybe you want to just elaborate on the fact that if you work at the airport, you're in retail at the airport, you are literally closed down at the airport. You cannot trade. Do you want to ask a follow-up question, sir? Monique, I see your microphone is on. Do you want to ask a question? Okay. Anybody want to ask a question before we carry on? Okay.
Speaker, nie? Sit.
Sorry, what was that?
Ivan?
Yes.
Laura, yeah.
Oh my. Hello, Laura. How are you?
Getting you.
What can I do for you, madam?
Okay, so obviously we haven't been able to apply for June, so we haven't really had the discussion yet with any of our staff, and we've also tried to top up our staff salaries. It's been a month-to-month conversation.
So Laura, hold on a moment. So you've not been working for June.
We haven't been able to work at all.
So why are you trying to top up your staff salaries?
Because we just felt that was the right thing to do. Some of them are they are working reduced hours at home. They've maybe an hour or two a day. We're in education. They published a directive today for skills development providers. I haven't had the chance to go through it yet, but obviously ultimately it's going to be up to the guidelines that's just been published. So we're not sure when we're going to be reopening.
All right. So Laura, hold on a moment. You've said a whole lot of things, and I think that what you've said, people should take indication from. Now, the fact is that if these people have been trading, if they've been working from home and you've been paying them to work from home, they are not eligible for TERS. So by them working from home, even if it's for a couple of hours, if it's official, if it's something you're declaring, then you are invalidating the TERS application. However, what you are doing is activating their ability to apply for short time pay. So they're entitled to apply for what is the equivalent of TERS for the difference between what you're paying them and what they ordinarily would get in terms of hours, but they would have to apply on their own rather than through you.
Okay, so obviously the staff that hasn't been able to work at all, general staff,
they remain locked down until the last day in June.
Okay, so the remainder, we'll have to have a conversation obviously now with our staff because we have to look at the directive. It also doesn't mean that we're going to be getting any training in. So in terms of the agreement now with the staff, going forward, we haven't really had an exact conversation with every staff member, and we're not sure whether the extension of the temporary layoff, do you do it on a month-to-month basis?
Okay, so let's just unpack that again, and thank you for the question. So the bottom line is that you now you've got no choice. You initiate now, if you haven't done it already, a Section 189 process. In terms of the Labour Relations Act, you are now initiating a Section 189 discussion with them, which is a dismissal based on operational requirements where you will look at alternatives. Only once you've initiated the Section 189 discussion in terms of 189.1 and 189.2 will you then, only once you've initiated the discussion with the staff member, dear staff member, we're locked down. We're not trading. We do not believe we're going to be trading for a little while. So we are now engaging with you in a Section 189 process. One of the results of Section 189 could be a dismissal based on operational requirements, in other words, retrenchment. However, there are alternatives, and why we're writing to you is to engage with you in a discussion on what those alternatives will be. When you write to them, you do please need to take care of what's in 189.3, and I'm just going to read it to you. I'm just going to read you what's in 189.3. The reason for the proposed dismissal. So, dear Laura, it is possible that as a result of this 189 process, we might need to engage in retrenchment for dismissal. That's if, I'm going to read you the whole thing. When an employer contemplates dismissing one or more employees for reasons based on the employer's operational requirements, the employer must consult any person whom the employer is required to consult in terms of a collective agreement. And if there's no collective agreement in terms of your workplace forum, if there is a registered trade union around, even if you haven't got an agreement with them, then an engagement with the trade union. And if there's no workplace forum around, then in discussions directly with the employees. So you have to engage with the employees where you're saying to them, we're looking at the end result, which might very well be dismissal. However, before we get to dismissal, let's talk. Now, what we'd like to do is avoid dismissal. In other words, avoid retrenching you. But to do that, we need you to agree to one or more of the following solutions: short time or temporarily lay off We anticipate that we might be able, Heinrich, in your instance, you might be able to say to them, we anticipate that at the end of August, the airports will open again for retail trade, which means September or October, which means that we're requiring you to agree to remain laid off until then. Laid off either means no work, no pay, or it means we'll pay you minimum wage, which is 3,500 Rand, but nothing more than that. Totally dependent on what either employer can afford to pay you. I'm not obligated to offer you if you're not going to work. However, if I am offering you something, I have to at the same time offer you retrenchment as an alternative to accepting what I'm offering you. Retrenchment will be your notice pay plus 1 week for every year of service plus your statutory monies. But the bottom line is you have to have this engagement with your staff member before you make any decision. You cannot make a unilateral, whereas you for April, for May, and for June, the Department of Labor took away from you the accountability and responsibility for engaging before a temporary layoff was agreed to. They've now put that back in your court. You cannot depend on legislation or the current state of disaster. You have to have an engagement with your staff member, and they have to agree to be temporarily laid off, or alternatively, to be retrenched from your business. You please need to understand this. Whereas previously it was a passive decision that you were allowed to be making as an employer, I'm putting my staff on temporary layoff. You are now having to activate a discussion and decision-making process before you implement a temporary layoff, or in fact anything else, including putting your staff on short time. So it's a process that you are now accountable and responsible for as an employer, whereas previously you were not accountable or responsible for it. The president took away that responsibility when he declared a state of disaster. Do not run your affairs as if you are anticipating that either today or tomorrow, the president will automatically make an announcement that TERS will be extended for at least July, if not August and September. There's a possibility, but do not live your life as if that's automatically going to happen. I cannot stress that enough. Every indication up until now from every minister, including Patel, including this person who runs employment and labor and his Politburo, every indication has been that there will not be an extension of TERS. But knowing our president and knowing this government, any pressure whatsoever from the labor unions might very well result in TERS being extended. When you are told that TERS was opening, I think, on Thursday last week and then crashed, but is going to open tomorrow or the next day, what that means is it's opening for the applications to be made for TERS for the June payment and for the May payment and for the April payments where those payments have not taken place. Not that TERS is opening, ladies and gentlemen, for July or August or September. TERS doesn't exist. It hasn't been activated for those periods. I just want to have a quick look at the comments that have been made. Can you still claim UIF when they are temporarily laid off from the 1st of July? The answer is no. There is no UIF TERS, UIF Temporary Employee Relief, from the 1st of July. UIF TERS will still be operational in July and August and September and October, but only for claims for the April, May, and June period. So in answer to your question, the answer is absolutely, you cannot claim UIF TERS when they're on temporary layoff. However, if they're on short time, then you can claim TERS. If they're on short time, then you can claim UIF for the short time, the difference between what you're paying them and what they ordinarily will receive. However, they have to do it on their own. And I'm going to say this again, ladies and gentlemen. Do not be fooled by anything that this lying Department of Employment and Labor are saying every single day and have been saying for the last. Do not trust them when they say, we'll ask the employer to manage the application process, even if it's only for short time. They will bounce it back at you when their system crashes, and they will blame you, the employer. And as things stand at this moment in time, pass everything, including, by the way, the application for TERS for June. Pass that on to your employees. Your employees can claim personally. Refuse to claim as the employer because the system is defunct and broken. Don't pay your employees. Let them claim for June, but from TERS. That's the absolute statement I would make. Obviously, many of you feel a responsibility for your employees, but I'm saying in an absolute world, I would be saying to you as employers, pass the responsibility for claiming for TERS to your employees. Why is that? Department of Labor have told your employees they've already paid you. They've lied to them, but they've told them they've already paid you. They've said to them, go online with your employment your ID number, and you'll be able to see what we've paid your employer. But what they're talking about is the part payments they might have made in April for some employees, but not all employees. And the bottom line is they set themselves an intention to set the employer off against the employee. So the focus is not on how the department is defunct. And I'm saying to you, give up the ghost. Do not keep chasing the Department of Labor any longer. Say to your employees that if they want to be paid TERS for June, they've got to make the application for the payment themselves. Do not make the application on their behalf when the opportunity to make the application opens up again, because I am guaranteeing you it will be bounced back at you. 25% of you will be paid properly, and the other 75% won't be paid, and they'll blame you, the employer, in the process. I cannot emphasize that enough. Just to clear understanding that, I'm just reading a question, just to clear the understanding that this principle will apply for staff in the tourism industry that can't work until the international borders open. Melissa, bottom line, TERS does not exist after the 1st of July. Irrespective of the industry, TERS does not exist. AD says, did I misunderstand that the state of emergency was extended to the 15th of July? Does this not affect the discussion? The state of emergency was extended to the 15th of July because it can only be extended on a month-by-month basis. It will be extended to the 15th of August and then the 15th of September. But the bottom line is, TERS has no or the state of emergency being a declaration has no bearing on TERS being alive or dead. When TERS was first created, it was created for the April, May, and June period. It was gazetted as such for April, May, and June. It hasn't been extended. There's a possibility it might be extended, 80, but you don't live your life by that possibility. I cannot stress that enough, ladies and gentlemen. Kate says, if the employees come back with a variety of agreements, can that be implemented, i.e., one department works short time, another reduced pay, and high-risk employees remain at home at reduced pay? Does that constitute? Of course that constitutes. From now on, Kate, the destiny to govern your workplace is completely in your hands and no longer in the hands of the Department of Employment. However, it is completely in what is referred to as the participative social partnership between the employer and the employee. Our labor law is predicated on the social partnership, which means now that whatever you do in terms of those three variations that you've written to me about, you have to do by agreement with your employees, where if they do not agree, then they accept retrenchment as an alternative. So that entire agreed situation that you've just written to me about, Kate, that entire agreed situation would have to be reflected in a Section 189 agreement with them, or an agreement with them which doesn't have to be Section 189 if there's a complete agreement. What happens if a few employees refuse to agree? If they've refused to agree, then the Section 189 process says, well, it's short time. I'm just going to read what you've said. One department works short time, another reduced pay, and high-risk employees remain at home. So if those are the alternatives, and they do not accept those alternatives, the only other alternative then is retrenchment. So, dear employees, these are the three things on option as a result of our engagement with you. If you accept none of these three things, then you are automatically hereby notified of the fact that you're retrenched. That's the consequence of our Section 189 process. This is important, Kate. I just want to take your last point, which is the one about the high-risk employees remaining at home. Even that is a result of a Section 189 process now. So whereas while UIF TERS was still operational with a temporary layoff, then that certainly did apply. You know, over 60 or with comorbidity, they would stay at home. It now has to be as a result of an agreement between the social partners, business and labor in the business. If those people over the age of 60 don't agree, then it's retrenchment. If those people who have comorbidities such as cancer or diabetes or whatever it is don't agree, then the only other alternative is retrenchment. Because, and this is why it's so important in terms of your question, Kate, while our labor relations has now reverted back to the LRA and basic conditions of employment, the disaster regulations still make it not preferred that those people over the age of 60 or with comorbidities return to the workplace. That's still in the regulations, which means you're caught between a rock and a hard place. And your employees must be made to understand, guys, you are at risk. There is still a virus. We haven't even hit the peak of the virus, which means you're not coming back to work, which means if you do not accept some altered state of an employment relationship that we're offering you, then unfortunately the only alternative is retrenchment. I know I'm sounding very hard and very harsh. I'm talking as an employer needs to think. And unfortunately, the majority of you who are employers also have a heart. At this moment in time, I'm asking you to take the heart out of your chest and leave it in the freezer until we're finished, please. All right, Lynn, do we need a certain document from the accountants, like a U19, for the employee to claim for short payment for June due to short hours? Lynn, all you have to do is give to your employees an explanation of why they're on short time that they sign and agree to. They then take that document to the Department of Labor's UIF division, and they then apply in the normal course of events. There's an application process at the UIF department for their hours of work being varied. It's a normal application process, and they'll be given all of the forms at the Department of Labor. They might bring those forms back to you to sign, but you don't have to chase those forms. All you have to do is give your employee proof of the fact that they have agreed, that you've discussed, engaged, and they have agreed to going on short time. Carol, in tourism, can the staff claim normal UIF during extended temporary layoffs? Carol, yes, they can claim unemployment because it's the unemployment insurance fund. But it won't be temporary employee relief, and there'll have to be a reason for that unemployment that is not related to COVID. So you have to create a reason for the unemployment which is not related to COVID, because remember, the normal UIF insurance products do not have space for COVID. They have space for dismissals, they have space for retrenchment, they have space for maternity leave, they have space for sick leave, but they're not written within the context of a pandemic. So you do need to understand that the TERS system was created to give an element of the UIF a context for the pandemic, but because that's now finished, it's expired and hasn't been extended. I hope I'm completely wrong by Wednesday, by the way. I'm hoping by Wednesday we'll see a gazette that extends TERS, because then it makes your lives easier. But if not, you have to activate the process. And it has to be on the basis of the fact that our business is suffering and therefore it's no work, no pay. You continue to be temporarily laid off because you've chosen that instead of being retrenched. Wayne, what happens if you can't afford the payout for retrenchment? Well, Wayne, it's interesting because the obligation is for you to offer a retrenchment package to your staff. However, how you pay that retrenchment package is absolutely up to your realities. Now, your reality might be, well, we've gone bankrupt. So if you've gone bankrupt as a business, they become preferential creditors and they have to stand in line with all of your suppliers, your landlord, and all the other preferential creditors. However, if you haven't gone bankrupt as a business, but you cannot afford to pay them a retrenchment package at this moment in time, you can defer the payments as long as they agree to accept deferred payments. You can pay them over time, over a 6-month or a 12-month period, as opposed to in one lump sum. You can do any of that. And I'm going to say what I said to one of my clients this morning. What I do not want to see you doing, however, is taking money out of your pocket to settle these bills. Because then you are validating the fact that the Department of Labor has made you responsible for the settlement, has made you responsible for the fact that your business has gone bankrupt. So I do not want to see you borrowing. I do not want to see you going hungry so that your staff can actually have income, because the bottom line is that is not going to be reciprocated. So the ordinary course of events will be, I owe you 10 Rand. I can afford to pay you R1 a month over a 10-month period. I understand you're going to go hungry, but the bottom line is at some stage, I have to reach into my chest, take my heart out and leave it in the fridge. Because as an employer, you have to make a decision for yourself first. Because remember, your staff are always going to be preferential creditors anyway if your business goes bankrupt and goes to the wall. They are going to be first in line to be paid anyway. I know I'm sounding very harsh and very hard, but I hope you understand why I'm saying what I'm saying, Wayne. Any other questions before I carry on? Please feel free, ladies and gentlemen, to literally unmute your microphone and just ask the questions. In a unionized environment, you have to be even more harder. Because what you have to realize in a unionized environment is your staff are sheep. They do not have a mind of their own. They have a collective consciousness. They have, in fact, what psychologists refer to as diffuse responsibility. Because they're acting in packs, because they're being directed by trade unionists and trade union organizers, they have diffuse responsibility where their psyche is such that they don't take responsibility for their own decisions. They don't have to. No one's going to point a finger at them and say, what do you think? So because they don't have to take responsibility for their own decisions, they don't have to make their own minds up, they act as sheep. And so there's even less reason for you to have to compromise as an employer in that relationship. I am begging you not to compromise, because when the chips are down in a unionized environment, there is absolutely no chance that your employers are going to remember the good times. Your employees are going to remember the good times. Your employees are going to remember how you bent over backwards for them. Your employees are going to remember what happened when you took care of their wives and their children, etc. That's not going to happen. They are not going to be allowed to have those thoughts because they're operating in a unionized consensus. So please, you have to take your heart out of your body and deal with them on the basis of what the law says. And the law says if you're retrenching them, 1 week for every year of service plus their notice pay, nothing else. And the law says, precedent says, that if it's going to take you 6 months to settle a debt, then take the 6 months to settle a debt. Don't go into debt yourself, further into debt yourself, just to be good to your employees. I cannot stress that enough. This is not what Virgin Atlantic guy, I've forgotten his name, would say. He says your most important asset is your staff. Of course, they're your most important asset, but they can also be the most difficult chain around your neck in times like this. You have to manage that obligation cleverly and brightly. There's a question here. Are unions availing themselves to these discussions in a timely manner, or are they buying time? Unions are taking the following approach, Kate. They are saying, we are not going to allow you to retrench. We are not going to allow you to engage in Section 189 discussions. We are going to do everything we can to delay it, and we are going to insist that the only time we're going to have Section 189 discussions with you is once we reach level 1. That's the approach that unions have taken. But we learned today from Pravin Gordhan. Pravin Gordhan today turned around and said to trade unions, if you guys push too far, if you guys are not prepared to engage, if you guys want to do everything you can do to crash these engagement and negotiations and discussions and want to stop us from reaching an agreement, we'll just walk out of the room. And so I'm saying to you, ladies and gentlemen, obey Section 189, Section 3, which is what you have to send to the trade union if you're in a unionized environment. But the moment the unions push, walk away. You simply write to your employees. You say to your employees who are affected, we cannot talk to your trade unions any longer. It is absolutely no use in doing that. We are talking to you directly. Here's a notice of retrenchment, and here's all the information contained in Section 3 of 189 that we have to give you. Take it. Well, quite frankly, take it or leave it. But that's the offer. It's not even an offer. It's our final offer on the table. Take it or leave it. And we completely bypass the trade union. And quite frankly, the trade union will go to court and say, well, you've undermined the relationship. As long as you can show that the trade union were undermining the engagement process and the consultation and the negotiation discussions, court will turn a blind eye to the trade union and say, sorry, guys, you didn't want to have these engagements and these discussions seriously with the employer. What was the employer supposed to do? Because on the 1st of July, now this is the important thing, the clock ticking says that on the 1st of July, the responsibility for honoring the employment relationship is back in the court of the employer. And the responsibility for paying the full package to the employee is the full payroll to the employee is now in your hands. So whatever action you take to try and circumvent having to pay a full package to your employee when your business is still closed down or only 25% operational, you take irrespective of the consequences of what might happen in the bargaining council, the CCMA, or even the labor court. What you have to realize is that if you retrench more than one person, the trade union will take you to the labor court. Labor court is just another forum. It's an arbitration forum. So your lawyer will go to labor court and will put your case to the labor court. The trade union will put their case to the labor court. And there is law and there is precedent that you can rely on. Never be afraid of being taken to the labor court. Because the bottom line is, as long as you can show you've tried to engage, but the trade unions have turned you down at every juncture, the labor court will say to the trade unions, guys, you made this whip for your back. We're not going to make new law here and say that the trade unions are right and employers are wrong. So that's precisely, Kate, in answer to your question, where you say, are unions availing themselves of these discussions? The answer is no. Unions are doing everything they can to frustrate engagement and discussions and agreement unless it's on what they want to see happen in the workplaces. Cabello says, is it still a must for the employer to engage with a union that has less than 50+ % members, i.e. 34% over and above the revised collective agreement hasn't been agreed upon by the union itself, even though it tends for the employer to resolve this? Okay, if you can show as an employer that you've notified the trade union that you're engaging in Section 189 processes, even though the trade union isn't a majority trade union, they don't have to be a majority trade union. Because in the absence of a collective agreement in the industry through a bargaining council that you're responsible to, in the absence of a collective agreement with a trade union, if a trade union represents some of your staff members, then insofar as their representation of those staff members are concerned, they become your engagement party. However, if they're not prepared to engage with you, then you tell them to take a running hike, Cabello. You give them an opportunity, you ask them to come to a meeting, and if they come up with, and trust me, they're going to come up with all technicalities. You're going to say to them, well, we had to send WhatsApps and emails because our employees were temporarily or remain laid off. And they're going to say to you, well, that's not giving them a written or printed letter, so therefore we're invalidating the process. So you say, fine, you're invalidating the process. Goodbye. We're not talking to you any longer. There's the door. It is time to take back your workplace. Now is the time to take back your workplace. And let me explain why I'm saying that. If you give in to your trade unions and their demands to you, and Cabello, I cannot say this loud enough. Please hear what I'm going to say now. If you give in to your trade union demands that this procedure happens the way they want it to happen, then one of the things they're going to ask you for is your management accounts and your annual financial statements. Then they're going to ask you for your payroll. Then they're going to ask you for all of your shareholder agreement, all of your shareholder minutes of your shareholder meetings, insofar as employees or retrenchment or any operational discussion took place. And you're going to open the door the moment you give in to what they want for them to say, hold on a moment, you say the company hasn't got money to pay salaries. However, what happened in that case on your annual financial statements? And why was this money shifted there rather than into a fund to take care of a provision for salaries, et cetera, et cetera, et cetera? Remember that the trade union is going to act like an idiot in front of you, but they are not idiots. More importantly, they are very, very bright people, these organizers. And more importantly, they have lawyers and they have accountants who service them on retainer. So all they need is your annual financial statement. They're not going to look at your annual financial statement. They're going to get their accounting team to look at it. And suddenly, even though you're a 100% shareholder in the business, they're going to ask you about what you're doing with income in the business because you've opened the door. There's no need to open that door. You're entitled to make any decision you want to make. Shareholders are entitled to make any decision they want to make in a business, and directors and operational and executive staff are obligated to follow those shareholder directives. And employees are not entitled to participative management to this extent. But the trade unions are going to read the Labor Relations Act to you as if you do have an obligation in that regard. And now's the time to show that backbone. Because if you don't show that backbone, you are screwed, my friends. I'm sorry to use such a harsh and vulgar term, but you are essentially, let me use the less vulgar term, screwed. Okay, so that's critically important. In a situation where you have some of your employees with a trade union and some of them with not in a trade union, please understand that you have to do your non-unionized employees the same courtesy that you do your unionized employees, which means that as much of an engagement as you might have with your unionized employee through the trade union, you have to have the same discussion, but directly with the other employees who are going to be affected by any of the Section 189 consequences. You're not obligated to have that discussion with employees who are not going to be affected by Section 189 consequences. In other words, the guys who are going to remain on full time because they're going to have work. You're only obligated to deal with the grouping of employees, both unionized and non-unionized, who are going to be affected by the outcome of your Section 189 process. So please understand that. That's critically important. The one thing I do want you to understand is that if in the Section 189 process, and you've got very limited time, you literally can't get a Section 189 done before the 1st of July, but you can get it done during the month of July before the end of July. So you're not without options. But the one thing you do need to remember is that during your engagement with your staff, well, there's two ways of looking at what I'm going to talk about now, and that's the right of recall. During your engagement with your staff, if you're a nefarious kind of an employer, then you are not going to mention the right of recall. You're going to leave it in the hope that either the trade union or your employees themselves are not mentioning the right of recall. If an employee doesn't ask for recall and you get through the Section 189 negotiation period, you're not obligated to offer a right of recall. What is a right of recall? Because this is dismissals based on, this is non-causative dismissals based on operational requirements. So it's a no-fault dismissal. Your employee is entitled to insist that because you are making the job itself redundant and therefore retrenching them, not retrenching them but leaving the job open so that you can put somebody else into the job, because you are making the job redundant as you retrench them, if within a period of time, and that period can be 6 months or it can be a year, but if within a period of time that job becomes important again to the company, then they have to have first bite at the opportunity to either accept that they can come back to work or reject the offer to come back to work. Remembering that it's not just for their job, but it could be for any jobs under their job or related to their job on the organogram of the business. In other words, anything they could practically do. If they do not ask for recall, so that it's not in your retrenchment agreement, then you're not obligated to do that. The next day, you can literally go and recruit for someone to be replaced in that job. However, the moment they do insist on the right of recall, or if you've offered it to them, It's either going to be because you've specified it to be for a 6-month period, and now's the right time to negotiate that it's 6 months, in other words, till the end of the year, and maybe till the end of January, so 7 months, or for a year. Ordinarily, it's expected it would remain open for a year, but common practice is 6 months. Any question about the right of recall? Because everyone seems to have this notion that I've spoken to that it's automatically expected. It's not. It has to be requested or it has to be offered, but it's not automatic. And it's not in the LRA, by the way. So you need to bear that in mind. Any questions about the right of recall? Okay. So, ladies and gentlemen, the point I'm trying to make to you is this, and I'm going to end off by emphasizing it. Come the 1st of July, the Department of Labor is transferring back to you the responsibility and accountability for managing your workplace in terms of your normal recruitment and contracting practices. There is no longer a safety net of temporary employee relief. Without a Section 189 engagement, there is no longer temporary layoff. You have to be aware of that. There is, by the way, now that I come to think of it, there's a different kind of temporary layoff, and that is if you anticipate that you're going to have to retrench more than 50 people in your workplace, you're entitled to go to the CCMA, and you're entitled to ask the CCMA for the original TER, the original temporary employee relief, which was training, which was recognition of prior learning, training, and then retrenchment. The scheme that the CCMA had and still has is for the generic temporary employee relief, where an employer anticipates having to retrench more than 50 people, asks the CCMA for UIF funding, because the CCMA is responsible for managing that fund, asks the CCMA for UIF funding for temporary employee relief for training and retraining before the employees are laid off. Now, what that does is, if the CCMA manages to get the Department of Labor to agree to give you that money, or it's negotiated by a bargaining council on behalf of its members, and you apply to the bargaining council for the funding will pay for training, the funding will pay for assessment, and in particular situations, the funding may also pay for a stipend, where you say, we're giving the guys a retrenchment package. However, we're prepared to keep them around until the recognition of prior learning and the training is completed if the CCMA pays for it. And during that period, the income that these employees will earn is regarded as a stipend, which would be paid by the CCMA. That's the original kind of temporary employee relief before COVID came along. And that's still on the cards as one of the UIF offerings. But the point I'm trying to make is the obligation to engage is now passed back to you as the employer. The question is this: what if during the temporary layoff, your employee contracted COVID, contracted coronavirus? Maybe even they're symptomatic from it, they're sick. Comes the 1st of July, your obligation to pay them sick leave, to remain either in quarantine or off work sick, but fully paid for the sick leave, your obligation is activated on the 1st of July. The Department of Labor have been very clever here. They've passed the obligation back to you come the 1st of July. While your employees were temporarily laid off, you didn't have that obligation. But they realized that TERS would end before we hit the peak in South Africa, and they did that consciously so that they could pass back to you, the employer, the obligation to carry these employees for sick leave on a new 3-year or 36-day cycle. So not just to carry on with the sick leave that were due to them in March, but on a new 3-year 30, because remember that 36 days is activated because they have been away from work, laid off, therefore not working for you for the last 3 months. The moment they come back, the 36-day sick leave cycle is reactivated from scratch. That's what you have to understand, ladies and gentlemen. So if your employees are currently sick, comes the 1st of July and they're not back at work, but they're sick, they have a doctor's note, they're on treatment, they might even be in hospital, you're obligated for a 36-day sick leave payment cycle for these individuals. You have to know that. And you're not allowed to engage in a Section 189 process while they're sick. Any questions? I know I've just landed a massive hammer on your head. Any questions about that? Please feel free to unmute your microphone, because this is a big thing. I doubt.
Hi, Ivor.
Yes, Renee, let me just say this and then you can ask your question. But I doubt too many of you have engaged with your employees over the last 3 months to the extent that you know, number one, whether or not they've been tested, number two, whether or not they're sick. I would ask the question. You've still got today and tomorrow to ask the question before the 1st of July. But you have to know if they're sick on the 1st of July, because you can't expect them to return back to work. Rena, I'm going to take your question, and then I want to ask, there's a confidential question that's come through around the taxis and whether or not that can legitimately cause you not to take employees back into the working environment. Sorry, Rene, you want to carry on with your question. I'm sorry to have interrupted.
How are you?
Fine, thanks, and you?
Fine, thank you. Every single staff member's sick leave on the 1st of July reverts back to 36 days as if they weren't sick in the last 7 months.
As if they weren't sick in the last 3-year cycle, yeah. Because think about it. You've had a break in their contract of employment. You've had a break in their, what's it called with pension funds, etc. And
Right.
You know what I'm talking about, the
Yes.
continuity of employment.
Right.
And you are resuming the employment relationship ab initio from scratch, not recognizing their length of service, but from scratch. And therefore that 36-day period kicks in, or that 3-year period for sick leave kicks in from the 1st of July again. You can argue, and you can be prepared collectively to take it as a dispute of interest to the Labour Court, that that's unfair and that there wasn't any legislative engagement or discussion in that regard. In fact, there's nothing in the Gazette in that regard. It's just something that the Department of Labour have said. Again, you can argue that there's nothing legislatively forcing it and you should continue with the sick leave record before March. They're going to argue that there's a break in the employment relationship and therefore 36 days start ab initio again.
Ivor?
Yes, Monique.
Hi, thanks for doing all of this. I'm sure everyone's finding it very helpful. So a big thank you for all your support and advice and information.
No problem.
Just a question is, can one offer retrenchment to some staff but not to all staff?
Yes, so remember, in retrenching, first of all, you can retrench on a department by department basis, and then you retrench using a formula. Now, ordinarily, the formula is LIFO, which is last in, first out. So you determine. So you engage in retrenchment because you still want to keep your business viable. But what you're doing for operational reasons, you're determining you need to cut your expenses. So, for example, you're going to say we need to cut our expenses by 25%. That means everything to do with our expenses, including our staff expenses. So therefore, we need to cut 25 out of 100 people, and we'll either do that in one department or multiple departments. If we do it in a way where we need to discriminate some staff members from other in the same job category, then we will apply LIFO, last in, first out. If we do it across the board, then we'll apply it on the basis of last in, first out at the low. We'll start from the lowest level in our business going upwards. So last in, first out cleaner, last in, first out assistant technician, last in, first out new artisan, etc. So you'll go up the scale, remembering that the people that are left behind will come down the scale to pick up the slack. So you can you apply the LIFO system. There are exceptions to LIFO, by the way, and that is critical skills in the business you need to retain. So someone might have started a lot later than somebody else, but have a much better qualification, maybe even better experience, or more relevant critical core skill experience that the older guy doesn't have. Then you can break with LIFO and say, sorry, guy, you don't have computer skills, but the guy in nappies does have computer skills, so we want to keep him because of 4 IR or 5 IR. So you can make an exception to LIFO, but it has to be as a result of engaging and applying your mind in that regard.
So you could offer them the two, say, last people in a certain department, LIFO, either retrenchment or a short pay of short hours, 20%, 2 hours a day type of scenario, and they can choose.
Absolutely. But that you put your finger on something. They have to be given the choice. If you're going to offer them something that changes their basic conditions of employment, it cannot be a unilateral decision, and they have to be provided with a choice in that regard.
Okay, thank you.
Good.
Thanks.
Rob, I see that there was a question you wanted to ask. I saw your name appear a little earlier.
Hi, Ivor.
Hello, Rob.
Quite a lot, the majority of our staff have been paid 80% of their salary through this whole lockdown. Does their sick leave also reset automatically then, even if they've only been short paid 20%, or are they excluded from this group?
Sorry, I'm not understanding your question.
You said to us that if people's employment contract is temporarily suspended during this time,
yes,
their sick leave resets.
Yes.
Now, if we've paid our staff, whether they've worked or not, but we've paid them 80% of their salary, does those people's sick leave also reset?
I think there's a different question. Have you claimed TERS for them?
Yes.
If you've claimed TERS for them, then irrespective of what you've paid them, they've been temporarily laid off. And if they've been temporarily laid off, then automatically it resets.
Okay, thank you.
Okay, Rob. Any other questions, ladies and gentlemen? Now's your chance. Okay, I just want to talk about the taxi issue. So here's the thing. I had a question from an employer that said that as of this morning, my employees who I know come to work in a taxi have now participated in committing a crime in South Africa. They've got into a taxi, and going into a taxi which is 100% full against the directives of the government, they have aided and abetted the taxi driver in committing a crime. So there are two issues here that I've been asked to comment on. The one is, in aiding and abetting the taxi driver in committing a crime, in getting into and therefore constituting the 100% of taxi cargo, should I allow them back to work? And the answer there is, in getting into the taxi, the aiding and abetting of the crime is not the issue. Yes, you do not want an employee who is a criminal. And if they've been in the taxi, they are automatically regarded in law as co-conspirators with the taxi driver in breaking the law. But more importantly, the fact that they've now been exposed on a 100% basis in that taxi, potentially to other people who have the virus and therefore can pass it on, you have an obligation to lock them out of your workplace. Because by allowing them into your workplace, you are increasing the chances of your employees contracting COVID through exposure to these people who've been in a taxi which has been a sardine can for maybe half an hour or an hour's trip to the workplace. Now that's your predicament as an employer. Do you just turn a blind eye and say, well, if they get it, but it doesn't have to be attributable to the taxi? Or are you allowed to anticipate that they could very well have increased their chances of getting it just by taking the taxi ride? During COVID, however, there was a requirement, and that is that you had to make transport arrangements. Do you know that, in fact, until Wednesday, you are still obligated to be the ones making transport arrangements for your staff to get to work in a safe way? I don't even want to go with what's on my mind at the moment, but just follow the line of reasoning in terms of co-conspirators. as an employer, the law was actually silent about your employees getting into a taxi. But the law was very specific as employers, as you having to make travel and transport arrangements for your employees so that they would get to work in a safe way. It's just something to consider. Point hasn't been pushed, it won't be pushed, but you just need to see it coming if it ever does come. Carol says, does leave also reset after TERS like sick leave? Carol, if you've not exhausted your leave, so remember, sick leave is not something that's put into the bank. It's a provision should your employees get sick. So at the end of the 36 3-year cycle, 36 sick day cycle, if your employees have not used their sick leave, they can't bank the sick leave. But leave is something that on a monthly basis accrues and comes out of your annual financial statement provision and into their trust fund for leave entitlement. So it belongs to them. You can never take it away from them. You can never neutralize it. You should, by the way, have forced them to take it during the last 3 months. Irrespective of what this minister has said, his statements have been against what the law stands for, that you were entitled to force them to take it. But if you didn't and they still have some leave over, then that leave accrues to them. It's theirs. You can't take it away from them. All right. Ladies and gentlemen, thank you so much. That's been fun. I hope you got some use out of it. Yeah, let's just keep talking. If the law does change, I will tell you. If they do extend TERS, I will tell you. And if you have any questions, please do not hesitate to email me. I'm only too happy to take your questions and play with you. Thanks so much, and yeah, have a good night.